Yes.
And at this location that you had responded to, your information was that there had been a shooting, right?
According to the report, yes.
You did not find any shell casings outside this house that had supposedly been shot at, did you?
No.
Because if you had, you would have photographed them and collected those shell casings, wouldn't you?
Correct.
And if you had seen any bullet defects on this house that had supposedly been shot at, you would have photographed those bullet defects, wouldn't you?
Correct.
Because that would have been important in the investigation, true?
Correct.
It certainly would have corroborated that a house had been shot at that you had responded to, true?
True.
Okay. What you did do, though, is that you photographed the trunk and interior of this vehicle in these photographs, States Exhibit 1 Foxtrot through 22 Foxtrot, right?
Correct.
Okay. And in that vehicle, there were some guns found, right?
Correct.
So you got a vehicle, 3 guys in it, and 3 guns that you collected, right?
Correct.
Okay. Now, it wasn't done at the location, but I think I heard you say earlier that at Zone 3, you were the one who did the gunshot residue test on those 3 individuals, right?
Correct.
And I think if I wrote down your response correctly, you said there's really not a whole lot of technicality to it. There's a kit, you open the kit and you follow the directions, right?
You read the instructions and follow the instructions. Yes.
Okay. Now, the individual, and you were the one who was actually interacting with these 3 individuals who were in that car where those guns were found, right?
Interacting.
Well, I mean, you had to interact with them in order to do the gunshot residue.
Process the gunshot residue kits.
Right. Right. I mean, you have to interact with the individuals, right?
And the process.
Say process.
So,
Make a feel.
Kelvin Watts, Jermaine Hardiman, and Jamal Baines were the 3 individuals who you did the gunshot residue test on. Isn't that right?
I don't recall.
You don't remember the names?
I don't recall.
Did you put it in your report?
I don't recall.
You don't. Well, it's in front of you. Take a look and see it.
Woo!
Hold on 1 second.
Cause you calm down. He cool. He cool. Y'all officers coming in there.
There's
Like
only one name on my report.
What?
Okay.
What name?
What were the results of the gunshot residue test?
I don't have that either.
What?
You don't recall?
Maybe the GBI does,
Okay.
because that's where the gunshot residue kits go.
Okay. And so, at any time after you performed the test, I presume you sealed it, right?
Correct.
Okay. You were never advised of what the results were?
No.
Okay. The other incident that you were asked about, let's see, that would have been the Metropolitan Parkway. That's it. And that is the one where you took photographs that have previously been marked, identified, and entered as States Exhibit 1, it says indigo, to 61 indigo, right?
Yes.
You responded to that location because there was, the information you had was that there had been a shooting out front of a location, correct?
Correct.
Not a shooting of a person, but just a shooting period, right? And there were vehicles that had sustained some bullet, what you determined.
Yes.
Okay. You took photographs of them.
Yes.
You collected shell casings.
Yes.
A total of how many?
7.
7 shell casings found where outside the location that you responded to.
Yes.
And refresh my memory, what was the address of that Metropolitan Avenue location?
675 Metropolitan Parkway.
675 Metropolitan Parkway, that is a business establishment, is it not?
According to the pictures.
Okay.
Yeah, my
And
boy.
would I be correct that, as in the previous cases, you did not personally interact with any individuals, witnesses or otherwise at that location?
Correct.
You just took photographs of the vehicles that had some damage to them, yes?
Correct.
And you scoured the area and found some shell casings and collected those, right?
Correct.
All right.
Boy, sharp today.
All right. One moment, please, Judge.
Yes, sir.
Thank you, Judge. That's all I have.
Mr. Sharp, go ahead.
All right, start ready, boy. Woo.
Good afternoon.
Good afternoon.
I'm just going to ask you a couple questions about the April 12th, 2015 work that you did, okay?
Okay.
All right. I noticed all the photos that you took were outside, correct?
Yes.
And when I say outside, outside the residence of 1987 Fremont Avenue, correct?
Correct.
Okay. And that vehicle that was parked it was parked right in front of 1987 Fremont Avenue, correct?
Correct.
You never entered 1987 Fremont Avenue, did you?
No.
And to your knowledge, no law enforcement ever searched inside 1987 Fremont Avenue in search of any guns that may have been discarded there, did they?
I'm going to object to speculation.
I asked to her knowledge.
It calls for speculation, guys.
Yeah, it does. I'm gonna sustain the objection.
Are you aware of any law enforcement searching that house for discarded firearms?
Same objection.
And, yeah. Sustained.
No further questions.
Anyone else?
Mr. Shaw.
Any redirect, Mr. Brown?
Mr. Shaw. Try to use psychology on them then.
A few questions for you.
Thugger. My boy. Still.
On cross-examination, you were asked a few questions by Mr. Williams's attorney, Mr. Adams, and he asked you if you searched for your surveillance cameras. Do you recall that question being asked of you?
Yes.
When you respond to a crime scene, what is your primary purpose for responding?
Process the crime scene?
Are you responsible for looking for crime scene surveillance footage?
No.
Upon us responding to a crime scene, is it customary for crime scene technicians to take pictures of property or things involved in the crime scene prior to moving?
No.
Okay. Is it, excuse me, earlier you were asked a question on the cross by Mr. Adams about how the vehicle was moved or where it came from. When you respond to a crime scene, is that part of your responsibility to know how a particular piece of property arrived to where it did?
No.
Is knowing who was in a particular vehicle a part of your investigation?
No.
Are officers required to preserve a crime scene prior to your arrival to you?
Yes.
Earlier, you were asked some questions with respect to blood that was found at the location pertaining to the first incident occurring on April the 12th, 2015. I want to reorient you today. You were asked by Mr. Adams if you found any blood near the intersection of Harper and Brownsville Road. Do you recall that question?
Yes.
And your answer was, no, you didn't find any blood in that location. Do you recall that?
Yes.
Did you find blood at the 1987 Fremont address near the blue vehicle?
Yes.
Did you find any blood inside that vehicle?
Yes.
Where was the blood that you recall finding at that location?
At 1987, on the ground and in the car.
I want to go and redirect you to a few other questions that you were asked on the cross. You were asked if you went into the 1987 Fremont address. Do you recall that question being asked by Mr. Adams?
Yes.
Were you aware at that time of any of the 1987 Fremont address, the residents at that address being involved in this particular shooting incident?
No.
Would you have had any reason with that knowledge to go into 1987 Fremont Street to take pictures of someone's home?
No.
Just briefly, Ryan. Earlier, you were questioned about whether you spoke with anybody when you arrived to the 1987 Fremont address. Do you recall those questions?
Yes.
Is it your responsibility to question anyone upon your arrival to a crime scene?
Not other than the investigator or the lead officer.
Okay, whose responsibility would it have been to question any such persons if they were there?
The officer.
And to be sure, is it fair to say that you were a civilian employee of at that time of the Atlanta Police Department?
Yes.
No. I want to ask you a few questions about follow up on a few questions that were asked of you with regarding shell casings. Earlier on cross, you were asked about shell casings being found, if they were found in the vehicle, the blue vehicle, or outside of the blue vehicle. Do you know such question?
Yes.
Does not finding shell casings mean that shots, excuse me, I need to rephrase. You were asked questions, you recall being asked questions by Mr. Adams with respect to the 1007 Hill Street shooting that occurred.
Yes.
And do you recall him asking you about shell casings and if any were found at that time when you responded to that location?
Yes.
And does not finding shell casings mean that shots weren't fired?
Objection, Your Honor, calls for speculation. I'll sustain the objection.
I'll turn your attention to another question that was asked of you on cross by Mr. Adams. You were asked about gunshot kits. Do you recall those questions?
Yes.
And specifically, you were asked about the follow-up with respect to gunshot kits that are processed by yourself. Do you recall that?
Yes.
Let me ask you this. Is it your responsibility after having processed the crime scene to follow up on the results of a gunshot residue kit?
No.
Okay, whose responsibility might that be?
The officer or investigator.
Okay. Is it sometimes the case during crime scene investigations that more than one crime scene technician will respond?
Yes.
And do you know a crime scene tech where?
Yes.
Okay. And as it relates to the 1007 Hill Street shooting that occurred, do you know if crime scene tech where responded before you did?
I don't recall.
Okay. Just a few more questions, Your Honor. Earlier you were asked on cross if you personally interacted with anyone at the 675 Metropolitan Parkway address where the shooting, the second shooting occurred. Do you recall that question?
Yes.
Would it have been your responsibility at that location to interact with any lay witnesses should they have been?
No.
And on cross, you were asked by Mr. Sharp, the attorney for Mr. Stillwell, if when you responded to the 4/12/2015 shooting, he asked you, were all of the photos taken outside, or something to that effect. Do you recall that question?
Yes.
Would you have had any reason or basis to go into any home on Fremont Street?
No.
Okay. And why wouldn't you have gone into any home on Fremont Street to take photos?
I'm the officer investigator. Wasn't there to tell me that or direct me that.
I'll ask you a better question. Is it fair to say that you didn't go into any homes on Fremont Street because of the shooting?
I stand as the form.
Okay. I'll rephrase your honor.
Get on, Shaw.
Where did the shooting take place that brought you to that resulted in you coming out to the Fremont Street location on April the 12th, 2015?
Repeat that.
Sure thing. To your knowledge, based on your report, where did the shooting occur that resulted in you responding to the Fremont Street on April the 12th, 2015?
1987, Fremont.
Let me ask you a better question. Does that, when you arrived, did you find the evidence that you collected, I'll rephrase, was the shooting inside or outside?
It appeared to be outside.
A few more questions, Your Honor.
You already said it. Mm-mm.
Just a few more questions for you, Mr. Robinson. When you and I'm turning your attention back to the April 12th, 2015 shooting to which you responded as a crime scene tip. When you arrived to the intersection of the Harper and Brownsville Road streets, was there a white Dodge Nitro anywhere near that scene?
I don't recall.
Do you recall when you were at the Harper Brownsville Street intersection, if a Walter Murphy ever came on scene to tell you he was shot at, that he shot at the blue truck?
I don't recall.
Okay. When you arrived to the Harper's Street and Brownsville Road intersection to further your investigation, did a Demise McMullen ever come to tell you that he had shot at the blue car that was there?
I stand the objection to the form. That was Mr. Sharp.
I'll rephrase your.
Okay.
Do you recall when you responded to the Harper Street Brownsville Street?
Basis. Try a little harder. Now. Overruled.
I'll continue with the question. If a Demise McMullen ever came to tell you at the Harper's Street
You trash,
intersection that he had shot at the blue car that you had processed? That would call for hearsay.
I stand the objection to the form.
Did a Demise McMullen ever arrive to the crime scene that you processed at the Harper Street and Brownsville Road intersection?
I don't recall.
Okay. And final couple of questions, Your Honor.
You said that about 5
I
minutes ago.
thanked you.
So come on, let's wrap it up.
Yes, Your Honor. Yes, Your Honor.
You said 5 minutes twice.
Did a Rodney Allison or Kevin Sherwell ever show up to the Harper Street and Brownsville Road while you were processing the crime?
I don't recall.
See, even the police don't remember. Detectives. So how you think the
And
kids?
were shell casings found at Harper and Brownsville Mill Road.
Yes.
No further questions, Your Honor.
About
Mr.
time.
Adams?
Get him, Adams, with that little sharp town boy. Handsome young man.
Hey, you asked a couple questions about who did or didn't show up at the Brownsville location. Let me ask you something. When you got to the location where you saw the car and the blood, was there a Cornelius Davis hanging around to give you a statement about what had happened in that car?
I don't recall.
Okay. What about D'Angelo White? Was there D'Angelo White hanging around what had happened in that car with his good friend?
I don't recall.
Was there anyone there to deny that they had tried to rob folks in the car and that's how the shooting occurred? Anyone there give you any statement like that?
I don't
don't recall.
Okay. You were asked about a lot of questions about your responsibilities as a crime scene technician. Now, when you show up as a crime scene technician, you're not just a casual observer. You actually collect evidence, isn't that right?
Yes.
Evidence that can be used in an investigation of a crime. Is that true?
Yes.
All right. So when you were asked a question about whether it's standard to take photographs of property when you arrive at a crime scene, in the Hill Street location, right, the Hill Street incident, where the allegation was that a house, a piece of property, was shot at, does it seem reasonable to you as a crime scene technician that you would want to take photos of this house that was supposedly shot at?
What objection?
I'll stand the objection.
I can research Jetson for what?
Well, but you didn't take any photos of that house, right?
No.
Okay.
Oh, it's so hard to say no.
In regards to the questions that were asked of you about the Fremont location, and whether or not you would go in there to collect evidence, whether you'd find any evidence in there. How do you know if there's any evidence
Right.
in a house to collect if you don't even go in the house?
Yeah. Thank you.
I was directed to this car. This is the location.
And that's it, right?
At the direction of the officer, yes.
Right. And your response to to the prosecutor a little earlier about the responsibility not being yours, about making a determination about this house and if there's evidence in the house, you said that that is the lead officer's responsibility, right?
Yes.
And so, but you don't even remember who the lead officer was that night, do you?
Correct.
But that lead officer would have prepared a report, I presume, right? They normally would, right?
Correct.
Okay. And that, whoever the lead officer is, although you wouldn't be able to come in here and tell us about why police did or did not go in a location where a car that had been shot was found in front of, the lead officer or detectives or police officers would be in a position to tell us that, right?
No objection, Your Honor. That calls for speculation.
I'll stand the objection.
You were asked, almost done, that about shell casings, the fact that there were no shell casings found in front of the Hill Street location, that doesn't indicate that there wasn't any shooting there. You remember that question?
Yes.
Well, at the Metropolitan Avenue location, where there was alleged that there was a shooting in front of this structure, this property, you actually looked for and found shell casings, right?
Yes.
Confirming what had allegedly occurred. True?
True.
No shell casings in front of Hill Street to confirm, or even defects to the house to confirm the report of a supposed shooting that had taken place there, right?
Objection, speculation, Your Honor.
I'll stand the objection.
All right, that's all. Thank you, Judge.
One question, Your Honor.
Hold on.
Good job, young man.
All right, we're gonna find out one question. All right?
Ms. Robertson, were there any shell casings found in front of 1987 Fremont?
Objection, absent answer.
Overruled.
I don't recall.
Could you take a look at your report?
She
And tell me
said that.
where it is that, the report pertaining to the Fremont shooting?
She said she didn't recall.
And I'm looking to see if I found shell casings in front of Fremont.
1987 Fremont.
No.
Is that your answer?
Yeah. She said no before.
All right. May Ms. Robertson be permanently temporary excused as a witness.
Yes, she may be permanently excused.
Madam, thank you for your patience with us. I'm going to excuse you permanently as a witness. That means you don't need to come back, but just don't discuss your testimony with anybody except.
She not come back, y'all. She out. Now, right here, what she got to say. The state has to say after they took their break. Let's see what the state didn't do their job, y'all. The state didn't do their job, and
Report. If a report winds up being tendered, I will certainly address that on the spot.
And under your order of Harris versus State, you put in a written order in this case. You said that the experts have to have a report. That's what the Supreme Court says. It's not mandated by the statute, but it's a better course, and we encourage that for our trial.
Yes, and you have made that abundantly clear through the experts that have testified who did not have a report. So I've noted your objection, sir.
And that coupled with no CV until today with Detective Gaither.
You have a CV now. You had the opportunity. When did you get it?
Today.
What time today did you get it?
Or last night.
Are you sure that you didn't get it sometime during discovery?
9:04 this morning.
Was it tendered during discovery at any point in time on behalf of the state?
Oh, I'm sorry, I thought you were talking.
State, was it tendered at? Tell me what date it was tendered.
And that's what we're trying to see. We're looking right now, Your Honor.
Then
It is a single page, and it is the document that they do have now.
That's not the point.
And I know that I'm looking for what the court has asked me for, and Your Honor,
she trying to be slick.
may I make the 2 more points, Judge?
Yes.
As she's thinking, yes.
Just for clarity. And then we are, as opposed to United States versus Ware, which was cited by the state, we are challenging qualifications and reliability and helpfulness. And the reason I say that is because in Ware itself, this may not be an exact quote, but it's very close. Daubert hearings may be helpful in complicated cases involving multiple experts. Same section.
Multiple experts, but go on, you have to also get multiple scientific experts.
Well, in this case, I have multiple experts, and we're going to have the blending potentially of a fact witness and an expert witness, and you already said we're not doing that. We have to have a demarcation. It's just a lot of information, and I don't know what the expert is going to do that's in addition to and not cumulative of people you've qualified over objection. Detective Dennis, Detective Viverito, or Investigator Viverito, Detective Belknap, who testified, and Detective Underwood. So,
Your Honor,
from a point, to me, you should, respectfully, we should hear why this is not cumulative. And that's what my objections are. And I appreciate you letting me make the record.
You're welcome, sir. No, not a problem. Madam, did you wish to be heard on that last issue, Mr. Steele?
Your Honor, I was just going to say that we've not yet, the jury hasn't heard from anyone except Detective Belknap at this point. And Detective Gaither, we will be clearly marking and letting the court know at what point we would transition over into anything expert related. My anticipation was today we were not even going to get
She always have an excuse.
to that point.
So is the,
Specifically
I'm sorry.
here.
Go ahead.
She is specifically here, in addition to giving her background, what her training and experiences. Of course, she has to introduce herself to the jury, but we specifically are here to engage this witness regarding the Dexter Montgomery shooting, that she was one of the ultimate lead investigators on that case, was turned over to the gang unit, and she worked that case, and we are
So is she a fact witness?
She is, yes, she
For
will be
Dexter
both.
Montgomery?
Yes, yes, she is in fact, a fact witness for Dexter Montgomery. And, she will be tendered later on as an expert.
So she's not so at this point in time, she is not,
We will not be eliciting expert testimony from her today. We will not even be tendering her as an expert today.
well, I still need to read the admonition, don't
I don't believe so. I think it's at the point where we stop and start getting into the different, testimonies. Like when I stop with the fact, testimony and get into tendering her, asking the court to have her admitted as an expert. I think the point at which I asked that she be admitted as an expert is the point at which the court rightly give the demarcation admonition, if you will.
No.
Because everything that she's gonna talk about, at least today, first, will be background and fact. Her background with gangs, just the qualifications, but we will not be tendering her as an expert.
but I correct me if I'm wrong though, but I believe that I did give the admonition before Investigator Belknap testified.
I think Ms. Hilton says that you did, but I'm not certain that I remember the exact circumstances, whether she started with the expert and then went into fact. I think she started with the expert and went into fact. I am going to start with fact, so she's just a regular witness, and until such time that the state asks that she be admitted as an expert, I do not believe it's necessary that the court even broach the subject with the jury. I think.
All right. Okay.
Thank you.
Now sit down.
I just want to remind the court of one other issue, just in case it comes up. I brought up the issue last week about, or actually on Monday, I believe, about Investigator Robinson and the issue of an internal affairs investigation. And
yes, I remember that.
Ordered the state, and the state indicated that they may very well go into that, and you ordered the state to hand over all files that would be Brady material and hand them over to the defense. We have not received any of those files yet. So I just wanted to bring that to your attention in case the state starts trying to get into some of those things that we have not received anything as of yet.
That's with,
Investigator Gaither took over this investigation from that individual, I believe.
do we have, well, I said independently, have you found or located the internal affairs?
We hadn't asked for it. We didn't have it. I believe that we did request and receive some documents.
Okay.
That we will be providing to the defense, but we won't be getting to that person at all at any point today either. So.
It still needs to be turned over. So, Mr. Shaw, you just remind me again, okay? All right. Anything further?
Just for the form report.
She ain't did her homework.
We have motions outstanding if for the impeachment for Mr. Wilson.
I expect that to be done, and you all should probably work that out. I've seen plenty of conversations about it, but you all need to gather your heads about it in terms of whether or not, because I thought my instructions were pretty clear.
We won't be bringing any of that before today is up, so I believe that.
Now, Ms. Love, I'm gonna tell you.
With Love thinks she's
Before
slick.
it comes up, you should have redacted that particular.
That's right.
Parts that the court has instructed you. If you have difficulties, then that should be put into writing, and I should be able to decide about that. But I believe I ruled upon all of the Murphy statements.
They add more. That's all it is to it.
You're right, there's some additional.
I saw that.
Some of it's in conflict with what is her ex. And so the state is confused. So Mr. Shard in his motion asked for a particular portion involving Mr. Murphy to be redacted. Now Mr. Steele is asking for it to be in. We took it out. We already did the proper. We sent over the redactions as ordered by the court. Mr. Steele, this morning when we talked after he reviewed, had some objections to what has already been redacted. And so we disagree. And so I don't think there's anything except for the court to hear those disagreements. Because at this point, we disagree on these additional redactions. But we have done them pursuant to what we've discussed last week, earlier this week. Those are redactions that have been already turned over.
I like her.
And Your Honor, we don't, like I said, we won't be tendering those if the court will allow us to begin with the witness, and we can, if the court will allow us to further address those matters at the close of the, whenever the court sees fit today. I'd ask that the court allow us to do that outside of the jury being here.
She didn't want to talk.
Captain.
We need to take care of business. What is he typing up right there?
But we won't, yeah, there's no need to. We will not be playing the video today of Walter Murphy. And I believe it's a matter that only the court can reconcile.
Just be quiet and let the judge find the information. Because you're not prepared. Now you can sit down off your heels. She won't sit down. She ain't sat down yet. Ooh-wee. I think they got this team over here got their stuff together. But the state's supposed to share everything that they have with the defendant. That's a shot, but like a real cool dude. Mm-mm. He's thugging, y'all, thugging. Talking to his attorney, Mr. Steele. Come on, Judge. You supposed to have your stuff together, too, as a judge. It shouldn't take this long. I would like to give a shout out to everybody who had a birthday today, either celebrating a special day, promotion, a marriage, a baby, anything. Congratulations. Shout out to all my subscribers. Y'all doing a great job of thumbing me up and joining the channel. Appreciate you. Thanks. Shout out to my mods and shout out to Law and Crime and a couple more New Nation and Channel 11. I just want to tell everybody I appreciate what you do. Okay. Shout out to everybody who commentary, who lead, you're doing a good job focusing on what's going on in the crime. Appreciate you. But those who just
When
tuned
do you
in,
think you're gonna get to these, Ms. Love?
Tomorrow, Your Honor. But Your Honor, one portion of the Murphy interview where there's only Detective Dennis, Mr. Hudson and Mr. Murphy in the room. We don't want to put that portion in because it's in the room. So that part, we can agree to. We've been, I think, pretty accommodating and reasonable as it relates to, as it relates to requests for redaction. Where we have pushed back have been those areas where we believe it is perfectly admissible and not in any way prejudicial that the information is being portrayed on the screen. So, if the court, I would like an opportunity to, after court ends today, to briefly address it with the court. I would gladly come in earlier. Of course, the court is aware. I requested that we come in at 8:30 every day and leave at 6:30. I have no problem with that. I would like to get matters addressed before the jury is here. I don't mind how early we need to come in. I'll come in at 8, 7:30.
she still ain't doing what he asked her to do. And that's not fair.
To have us not able to properly address the concerns that we have with the redaction.
She's not a good prosecutor.
Puts everyone at a disadvantage when we are notified after we have complied with the court's instructions. And
You are the prosecutor.
was not only served 2 years ago, but 2 weeks ago, there was another notice of precisely the exhibits we intended to use. And the first time we hear about these particular redaction requests is the day we're putting it up. So it's a way that we are hamstrung. We're not allowed to put up our case in a fluid manner. So we would gladly.
I think she's not doing her job.
Stay as late as we need to hash these issues out. So I asked on the record again, like I did in the bench with Mr. Adams a few weeks ago before Mr. Weinstein ever filed his motion, that we be allowed to stay as late as need be and to come as early as need be to address these matters so that our cases aren't impacted negatively by any efforts of people that are different than.
You can't put your blame on nobody else. She putting the blame on the defendant and it's her fault. You can't do that. Now sit down. Sit down.
I'm gonna dismiss the jury for today. Sergeant Ingram, summon our jurors, please.
And she still, oh Lord, have mercy. I wonder why she left from where she was. Come on, Judge, now you got to keep your words. Not just for the prosecutor, but for everyone. State ain't got their job together. She ain't got the lead prosecutor not doing good. She's not doing her job. She's so busy doing other jobs. I know what's going on. I think the lady right here should have been the lead prosecutor. She is very professional. Her. With her work.
All right, thank you, Sergeant Ingram. Ladies and gentlemen, please be seated. All right, members of the jury, it's almost 5 o'clock today, and I think it might be a natural stopping point for you for today. So with your permission and concurrence, I'm going to go ahead and recess you all Bill's motion limiting number 50, which Ms. Weaver's already been included on, and I will include as the next court exhibit in order the email as well as the motion. Here's the problem, as I keep telling you all.
You don't keep your word.
Just try to say this as artfully as I can, but the challenge that we've been having thus far is that while you all are advocates and think that your position is one that you may be able to introduce evidence, if there is a disagreement, I have to take it up.
Yeah.
The problem is that this evidence or information has existed in discovery for the longest period of time. And what irritates the court is that I have to keep stopping. It's not personal irritation or otherwise. It's just that I've told you many times before that this jury in the box, we should present and try and minimize disruptions. This afternoon, this morning, was an exercise in disruption. So if you don't want me to exclude your evidence, then the 4-1 judge is a happy judge, means that you file something or you bring it to my attention way before the witness sits on the stand.
And you said
to kind
that.
of go through
Numbers are done.
edits. So to that point, I mean, I can't make it any clearer. And you all are trying to work yourselves into working on the weekend, because that's the only way I'm going to be able to get through this.
That's right.
I'm going to have to excuse this jury, and we're going to work on the weekend to get this done. So be it.
That's right, Judge.
If that's what it takes, that's what it takes. But I can't keep stopping in front of this jury and taking up things that
That's right.
should have forecasted as a problem. What I mean by that, I'm going to give representatives from the state of Georgia. Judge, we're going to go ahead and introduce his PowerPoint or whatever. We have some concerns. We brought them to the defense's issue. And here's the things that we were not able to work out. Because remember, you all are seasoned advocates. This is not your first trial. It's not like you don't know what you think is going to be admissible or not. And if you're uncertain about it, that's why you file a motion to limit. The defense has done so on many occasions. But you all drive the kind of the train in this, because if you don't present it, then a lot of times they won't know that there's a problem. Or, as I mentioned earlier, the exhibit changes or you add additional things and they don't have the opportunity to take it up. That's why I'm telling you that it's a problematic issue. So that's what I mean by being forewarned. If you don't talk to your opposing side about this,
that's right.
That's where you're going to run into problems.
And that's what the state's not doing.
Saying, well, if you haven't talked about it, it hasn't been presented to me, and the jury's sitting in the box, I'm going to exclude it.
Hey, baby.
At this point in time,
What's up?
I'm very frustrated, to say the least. And I'm just telling you that being forewarned is more than just 10 minutes before we go out, or
right.
coming early or staying late.
That's
there
right.
are some 30 people that have to get in this particular spot in one time. And I can't blame you all, and I won't blame you all, because the law doesn't prevent me to do that, for not being in the proper place and space you're supposed to. There are a lot of things that happen, because all of us have been out, and the court is very sensitive. Having been a trial advocate going from courthouse to courthouse, parking lot to parking lot, I understand what it takes to get in this courthouse in the morning. But you all have to be here a lot earlier, and you need to be sitting in your places. We need to be waiting on them, shouldn't be waiting on you.
That's right.
There are at least 6 sets of lawyers that have to get here. And you all should not be just sitting down when I get here.
You're
I
right.
tell you to be here at a particular time, please be here and be in place.
And that's
So
what the
I can go
judge
in
keep
and
trying to talk to them
stop.
about.
Because we eat up time that way.
But the state ain't doing a good job, though.
And I mean, I just don't know what else to tell you all. But I'm trying to be as patient as I can. But
They need a hard judge.
Lost for words at this point in time because I have said this over and over and over again. So if you don't want to see contempt, if you don't want to see us working on the weekends, then please change what you're doing. And Mr. Starr, the inquiry I made this morning is a valid inquiry. None of you would do this if you were in the United States District Court. None of you.
None of them.
My colleagues in federal court would probably jail most of you. And for those of you that have practiced in federal court, this is not the way it goes.
That's right.
From the state's perspective, as well as the defense perspective, everything's filed in advance. So why should you do anything less than in this courtroom? I don't see the same level of professionalism and
I'm saying it's a lack of professionalism. I told y'all that.
Need to do in terms of getting
You're right.
fleshed out. It's last minute. That's not fair to anybody.
That's right.
I got a rule on them. I really want to get it right for everyone. I'm the gatekeeper. I have no interest in the case other than see it's fairly tried. But things have got to change. That's why I asked that to you, Mr. Sharp, this morning. It wasn't for any other reason, because some of this stuff I'm just at a loss for. You all are seasoned advocates. It should not make a difference whether or not somebody.
But you can't put it on a defendant.
Who said what? If you know it's going to be an issue, flag it, present it, and let me deal with it.
They don't know until she give it to them.
Carve out a day so I can go ahead and deal with it. I can't deal with this.
Well, it's her fault.
Understand? That's not right.
It's not the state fault. Why you mad at him?
That's why I asked you that this morning.
Shoot, they not finding out nothing to the witness show up.
In the interest of trying to kind of get it right, please just modify your habits in terms of.
That's the state doing it.
Stop this last minute stuff. All right.
And she waits till her witness show up.
Motion in limine number 50, the redaction. All right, Mr. Steele, I have it. I marked it as the next court exhibit in order. So let's talk about
Yeah, no, I saw you.
So in paragraph number 1, you were saying this is the statements that were made on August 18th by Mr. Murphy? Correct. And you're saying it doesn't comply with my prior court order, all statements made by non-witnesses be redacted. So those were supposed to be redacted. All right, there's discussion you indicate regarding unrelated crimes that are not redacted.
That's true too.
So, and then the state redacted the exculpatory Brady evidence that Mr. Copeland, not a co-indictee, killed Mr. Thomas, and this is not speculation if it's co-conspirator hearsay. So let's just break that down. What about the unrelated crimes issue?
Your Honor, there is a conversation about other armed robberies. I'm looking for the exact time that I can point you to.
Hey, come sit down, Captain Minnie.
On the redacted version that we received this morning from the state, it should be at 11 minutes. It starts at 11 minutes. And again, it's Jacoby Hudson speaking. They talk about sex crimes. And then they talk about
I saw you at work on Facebook.
Cardinal Jack, a federal agent. He has so many charges. Jacoby Hudson, the lawyer, asked if they're prosecuting that case.
Okay, so
and to me,
that's from 11 to about 13:56, right?
Yeah.
Okay. Is the state seeking to introduce any of that?
The state asked the court to use that information before we make our argument. That's not my microphone. we asked that the court say be allowed to play the segment that we have just been.
What's the basis for its admission? Why do I need to hear it? I can read it and say, I can read it and tell you it probably doesn't have anything to do with what we're covering.
Well, Your Honor, the court and counsel are aware, our rules of evidence favor inclusion, and this is not inadmissible. There is nothing inadmissible about these portions that were brought to our attention, or else we would have flagged them. We actually agreed to take out things that were not permissible.
It's not relevant. It's not relevant. How is somebody about this conversation relevant for anything? What does the carjacking with federal agent have anything to do with it?
As the court recalls, when we last time excluded a chunk of information and attempted to play portions that became relevant when the witness not understand, we were denied the opportunity to do so. That is why we are asking that the court not so-called grant chunks of information be excluded without hearing the chunks of information and allowing the state the opportunity to point out the portions where we disagree.
We're not going through what we went through this morning, Ms. Love. I'm sorry. I am sorry. We're not doing that. I excluded that because look, I had made my ruling on that ticker issue. So I'm not going back and talking about that.
I have a question for you, because I think that the state.
I already ruled that we were going to exclude that particular portion. I ruled on it because we had argument on it. So.
Yes. So, Your Honor, the state just wants some guidance from the court. And the reason why we're asking for this guidance is we have your administrative order that was filed. And what the state did, especially when we speak specifically about Dexter Montgomery, on April 4th, as the court instructed, we turned over all of our evidence to defense counsel that we were going to use, everything. That included all these recordings that we're talking about right now. That included what you excluded, the portions that you excluded earlier. We turned that over on April 4th. We received one motion in limine about redactions. That was what Mr. Shard filed on behalf of Mr. Stillwell on April 10th. Then we got another one this morning on April 17th. So what the court asked of the state to do, we did in order to avoid any late arguments. What we understood from the court's administrative order is that state turn over the evidence so that defense counsel can review it. If there are any objections, they would file such. They did that for a portion of it. They never mentioned Mr. White's statement in this motion. They never mentioned any of the other redactions that are coming today.
I got it. So, but let me ask you a question. Are those particular portions admissible?
Which portion? From somebody, Mr. White, or for what we're talking, what Mr.
What we're talking about right now?
We have to go look at the earlier portion.
They always got to go look.
Of this statement, I believe it's the August 18th statement that we're referencing, is that in the room is Mr. Hudson.
Come here, Mimi.
Investigator Dennis and Mr. Murphy, and they're talking prior to the interview starting. Some things are relevant, some things are not. We need to look at it and decide.
But that's what you should have done already.
So we just got the information, Your Honor. We didn't know. All right. So the state believes that it should all come in. So if the defense has an objection, then they have to let us know so we can talk about it. And we actually had some conversation this morning.
Y'all blaming the defense.
To see what we can resolve. So we're trying to follow the court's instruction.
I know that, but I want you to go further. I want you to go further in the sense of you need to review your evidence before then and realistically kind of look at this in terms of whether or not it's going to be admissible.
But I mean,
because it's not like that's what I'm talking to you about.
They already filed a motion regarding this particular interview, and they didn't flag it, Your Honor. So the state is on notice about what they
I understand that.
And they literally list out August 18th. 2015, and then I think even Mr. Harvey had an additional redaction that we added to it. So we are following clearly what the court has asked. So this is what they objected to. This is what it is. If there was any objection earlier, they would have said that. So we would have been able to argue it a week ago when we argued this motion. So this is not a new interview. It's not old. This is the same August 18th, 2015.
It's the same, I know, but Mr.
So they never
Mr.
notified us. And Mr. Steele notified the state about objections. He did not. And so we didn't think it was an issue until he brought it to our attention.
I understand.
And we talked to him about it. We did not agree. And I think that is why Mr. Sharp brought it to the court's attention this morning about Mr. White, because we did try to resolve it. And I think he brought it to the court's attention because we could not resolve it and we wanted the court to make a ruling. And we were trying to find the time that the court was going to make the ruling in order for it, because we were following the instructions based on the administrative order. The order said, turn it over. We turned it over. They're going to launch whatever objections we have. If we can agree, we agree. If we can't, we bring it to the court's attention. I think that's what's been happening.
So, this 11 to 1356, do you have it queued up at this point?
One of four.
Now she more professional than this.
I understand what you're saying, Ms. Hill. You're saying that two defense counsels have differing opinions as to what should be redacted or included.
That's a different portion. That's not even this.
That's what they
right
do,
here. That's
Pepsi.
later on. And we redacted based on this what now another defense counsel wants in. But again, we were not put on notice so we can have that argument and hash that out. So we're trying to follow the court's instruction. We want to move this case along, and we're not trying to prolong it. But there are going to be times where the court, where the state and the defense are going to disagree, and we just want to make sure that we are properly following the court's instruction. And that's what we want to make sure.
But y'all not.
Guidance from the court.
Try not to, okay, I understand that, Ms. Hill. Just try not to do that like hours before I need to come, because that should not be what I'm feeling right now, that's more the rule than the exception. And I don't want to do, and the court doesn't want to do that anymore.
So what I'm asking is, if we disagree, if we talk about it and we disagree, should we then notify the court, say we discussed it and we still disagree? We think there needs to be a motion. I mean, we need to have a hearing, excuse me. So I just want to make sure that the court, before coming to court, is fully aware. We talked about it, we disagree, we may need a hearing so that the court is.
But y'all slick about when y'all do it
The
though.
earlier the better, because then I decide whether or not the jury comes in that morning, how long we need to do it. Do we need to work the weekend?
That's right,
Do we need
Judge.
I mean, what time do we need to come and deal with it? But the more in advance I get a chance to look at it,
That's what he's saying.
like I said,
And I believe that Ms. Love.
but this is not the way to do it.
This is not.
The way to do it.
And I think we tried to make calls earlier this week to defense counsel. Those calls may not have been returned, but I know that Mr. Sharp was dealing with some things as well. So there could have been a variety of reasons why those calls were not returned, but we were making calls as well to get this resolved in advance. So we want the court to be fully aware. We're not trying to wait till the last minute. Trust me, we are not trying to delay anymore. We want to get this case moving along.
You don't, at least you can talk like that, but you can't talk like
court
that.
instructions.
That's
and
my
not
girl
have it
talking now.
excluded after following the court instructions.
Let him know ahead of time. That's all he's saying. That's all the judge saying. Just tell him
Carry the
ahead.
flag, ma'am.
We're pulling it up. It has to play an evidence reviewer, Your Honor.
She don't never be on.
Just one, everybody should always be nothing but honest with each other in every dealing and profession. And I think that members of the state have done that and will continue to do that. And I know that the defense is trying to do that all the time. But I do want to raise one thing. When I received this today, the redaction today, that's what I filed, motion limiting number 50. You already ruled on motion limiting number 47, which I filed on 4/9/24. And I specifically wrote in paragraph 2 that the state has indicated it will potentially use interviews and proffers of Mr. Walter Murphy, which is what we're talking about, as exhibits at trial in the above referenced case. Then I wrote, Mr. Williams respectfully requests that, I wrote, without Attorney Hudson, becoming a witness in this case, Mr. Williams respectfully requests that these portions and any other similar portions where non-testifying third parties make statements on the recording be redacted. This includes, I also wrote, any jail calls. The admission of any non-testifying third party at a proper setting or meetings with the police violates Mr. Williams' constitutional rights and confrontation clause as well as inadmissible hearsay declaration. You granted it. The state today, and I'm not casting aspersions, when they gave the redaction, I was surprised. Because all this that I have in there, except for the Brady and except for the Mr. Copley who shot the man, it's Mr. Hudson. You've already ruled it out.
That's
So,
right.
for the state to say, and I'm not saying they're saying it wrong, maybe they forgot your rules, but those are all the issues. Mr. Hudson and Detective Dennis, I know you haven't seen it. I guess they're friendly. They get into a major discussion throughout this interview. That's what I flagged. So I wasted my time today to do what you already ordered.
That's right.
Because you want to have it in writing, and I'm trying.
I understand it. And
That's it. And that's all that there is. So for the state to say they got it today, or, there's conflicting.
That's right. Like y'all not right.
Mr. Harvey had issues. I had these.
yeah, I did rule upon that earlier, state. So, I mean, in terms of the statements involving Mr. Hudson. So,
Your Honor, I think the court should, I'd ask that the court.
She always got to argue.
That we carefully, Ms. Hilton was here that day, I was not, I believe, and Your Honor, the court, Ms. Hilton took diligent notes about what was to be excluded. I believe that the resolution to what we disagree on would be sought in what the court said on the record.
She just got to
Took
talk.
out the portions that the court ordered that we take out. Respectfully, Your Honor, I'm certain that there are areas where people can disagree, but I do know that we have been working very diligently.
She already said what you saying.
At her urging, as she was the one here listening to the court. So I'm not certain if there was a miscommunication, if one
That's
lawyer
the
heard
thing.
one thing and another heard something different. Perhaps the answer lies in the record itself. But we took out the portions we were ordered to take out. And as it relates to other matters, Judge, we do not have an agreement. We cannot agree on.
He already know that, ma'am.
Firmly, the court said that we should recognize things that might be a problem. We did, and we don't disagree on those. But the portions that are absolutely
She always been in over.
permissible, Your Honor, and that are only brought to us as a problem, the night before the witnesses to take the stand, we cannot read minds. They're entitled to argue about anything, but we have tried, and many times more Ms. Hilton
She
than I,
sure
we have
is.
seriously tried to be extremely accommodating.
And she's standing there saying this, what the girl just stood up there and said. Why is she repeating that? She want to argue. Argumental.
That's the place where we have to come to Your Honor, and respectfully, Your Honor, that's what happened today.
She want the last word.
With the way that if the defense counsel is allowed simply to make an
Just
objection,
talking.
and we didn't come up with whatever thing they found in some way could be possibly in another universe.
She like that judge.
Then the court has told the state that the court will exclude the state's evidence because they came up at 9:46 p.m. the night before after having this stuff for 2 weeks. And after hearing cross-examination of D'Angelo White, Your Honor, where Mr. Atkins specifically confronted Mr. White with the very statements they are now asking not to be included. The very statements, he literally verbatim asked Mr.
She
White
wanna argue.
over no objection from either of the defense. These exact statements, and now they want to keep them out because then it looks like he was arguing something or assuming facts not in evidence, when in fact, he was simply confronting the witness with a prior inconsistent statement, as he was supposed to do. So at 9:46, we did a motion in limine to exclude it, and they had this for 2 weeks knowing we were going to do.
No, they didn't.
exactly that.
He said they got it that morning.
They knew we were going to do exactly this. So we literally have been talking to them. I've called and said, talk to me, call me. Here, I've been told on the record.
Them little folks don't want to call you.
That's what was said on the record. We don't need to talk to her.
They don't need to call you on the phone.
Not to hamstring the state and leave it in the.
I'm not trying to hamstring you, madam, but I want you all to be prepared. It's ridiculous.
It is ridiculous, Judge.
We are sending over this
But I
final
am-
redaction.
But I do
And
not.
then we get this whole list of things.
She on the
I mean,
news.
it's
That's what she
very
right.
disruptive. We get it at 9:46 at night.
She just said that.
It's not fair to anybody. state, the jurors, the court.
That's right. That's
It's not fair to anybody.
Well, stop doing it then. I mean,
Stop doing it.
That's the thing, stop doing it.
And we have anticipated a lot, but the things to anticipate,
Well,
to anticipate, Your Honor, not,
madam,
yes, Your Honor.
I'm kind of just, I'm tired, okay? I really am. I really am.
Sit down.
Mr. Sharp.
Sit down.
I try not to belittle the point, but we at this point we have filed motions, and I have been filing motions the day before, and Your Honor has said certain things to me, and I accept that, and I'm not complaining to the court, but the things that I have filed in those motions are legal arguments that I never thought I would have to make, because I did not think the state would ever try to admit such evidence. Because we have all gone to law school. We all know what hearsay is. We all know what inadmissible evidence is. We all know what irrelevant evidence is. We all know that we wouldn't play recordings that talk about unrelated crimes.
That's
totally
right.
Unrelated crimes. We all know
That's
that
all
we
y'all
don't
they
play
been doing.
recordings where people say what other people said. So that's respectfully, Your Honor, and maybe I haven't articulated. That's why I haven't filed these motions. But when I see the state put in their anticipated evidence coming forward through investigator Dennis, a PowerPoint presentation that is just full of hearsay and full of
But nothing.
incomplete, irrelevant, extraneous
Thank you.
information, then I actually was put on notice at that time. I said, that state really thinks there's no rules to this.
That's
So
right.
I really need to start flagging everything. I was not trying to be disrespectful to the court by waiting last minute. I didn't think it was necessary to say, I want the state to follow the rules of evidence in
That's
the
right.
presentation of this case. I am now on notice, and I will be flagging everything I can think of, and try to have a happy judge, because you will be a forewarned judge. But I want you to understand that that's where I'm coming from.
I understand.
And so a lot of these things, I just didn't think we'd need to argue about.
She's argumental.
Let me hear the statement, the audio from 11 to 13:56.
Hey, old school, yeah. What's up? Now, them my favorite investigator when we was in pop shooting, we knocked him out. I heard you in the house right now. You on the freeway, 6 miles. I know me. You said a hundred, how many? You talking about David, David? Stupid ass nigga right in the door with me, bro. He done. Oh, they done. Fuck that TV, fuck these bosses. Yeah, because you want to know what? Because he gonna be there for a while. That's what I'm talking about. What supposed to? That ain't locked in talking. Nah, he probably about the other place. He ain't like, come on, we're about to go to the other side. She just like this. He got the color guy. He's slim, skinny, tall. Yeah, he got shot in the hip by the hobo. Yeah. Exactly what they said, too, in the dome. You don't get my wife. They call Jack the Federal.
That's
Yeah,
right.
I heard that.
Coke, that's
What you do?
Coke, that's how you doing?
Murder, red home invasion. I'm saying, babe. What you on that? Okay. So they was just, you got a car? So they was just, when he just working on every day doing shit, basically. $80 in one day? No. Appreciate it. He was playing grand with that father in real life. Say what? Oh, let me on camera. See, I'm going to shut up, bro. He shut up. Appreciate you, my guy. Yeah, those one moving. Well, yeah, they just, honestly, they just got over. They went over to, like, they was not taking it serious. Can anybody prosecute that, though? Is he prosecuting? I'll be serious. Who was gay? Yeah, he is a gang. He damn sure is put gang. I told him, I said, oh, yeah, what they say? And we folks are really. Shit, the real you with me, Gabe, and Lance. You old school. You know what's happening. Definitely. Y'all want to see that? Yeah. Lance Cross. New big ass folk bring out. No goddamn trying. Cause everybody. Scott Street. Cause everybody leave. Everybody on what you on. But shit, they want to say, yeah, we trying. Like, I don't know if you admit, AJ and Michael Lord. Michael, cool as hell, man. I know Mike.
Okay, baby. I'm good. I know I ain't seen you in a while.
Like, the real thing, like, I was still doing, like, petty drugs.
You ready to work? You sure you ready to work?
Yeah, but then, like,
Let me know when you ready to work.
I did all the pre-lives. I was signing off on 10 rich. Everything, shit, I spoke the language. Hey, you want to know I'm good being that other side? So, what we talk about? I told you, you need to think about later. So, if that means that you can see your son, you need to talk to them folks. Alright? I told them here. Alright? So, yeah, I'm busy in the rest of the club. You got good at everything. And I got it 2 million shots. And it's called high. Hold on. We'll get that person in here who handles the thing. Question though, he don't get the chance to see that though. Don't y'all just keep this right. Yeah. Like I don't want nobody like no defenders out there seeing that, bro. That Wall Smurf out there telling me, then I ain't gonna tell. I know. This is what you gonna say like this. And this on the radio operator. I grew up in the streets. She grew up in the streets. She grew up something in the south. I'm on the west side. I know same city. I know how the streets go. We not the one that will put your business out there. With people in the cell with you, your girl, the one cat that you think is your homie. Y'all tell her, you wanna know what happened? When you get up there, no. Listen, you must have good ass. Once I get on the phone, once you will put your business out.
So, Your Honor, up until the point.
What time is it stop?
This is not the point that we were talking about. He played it beyond the point that.
Yeah, I know that. So what, you started at 1100. Where'd you play to? I think almost 1600, something like that.
Probably should stop bending over in front of the camera.
It looks to be 1607.
Okay.
And Judge, the point up until where you hear Mr.
Yes, ma'am.
Your Honor, I apologize to the court.
Yes, ma'am.
Whew. Child. They upset the judge today, boy. Judge was on point. But like he said, if the state don't get them their paperwork earlier so they can file a motion, so the defendant can file a motion and give it to the judge in timely enough so he can read over the information, and then before the jury come out, now the jury got to go home. They going home. They appreciate they going home. Yes, honey, I've been running around straight to get my old son. Woo, we a surprise party. When his birthday? My niece's birthday was last night, girl. We karaoke, honey. And my daughter's birthday Friday. When his birthday, Pepsi? Well, them folks in that courtroom making a whole lot of money. Shout out to all the Aries. Okay, y'all, let me speed this up.
Time hacks are correct. At 1100 hours, 1100. Somebody starts by and says, well, Hudson knows and speaks about sex crimes to about 11:15, about first 15 seconds, all right? So what does that have anything to do with this case?
If that's at the very beginning,
Thank you.
I don't mind that being out, but we can't, the problem with giving a generalized description of something that's being said is that we could end up having excluded important parts that we don't agree to and that are relevant and not inadmissible. So that's why we are asking the court not to rely on a generalized description of a segment of a witness's interview.
Do you have a transcript of this particular hearing? I mean,
Yes, we haven't had time to correct it, but we do have a transcript and we're looking at it and we can provide it to everybody in the court to make things easier.
But you have to do that on a timely basis, like he said. When your son's birthday, Cold Pepsi? Only thing the judge said.
Let me ask y'all, well, that needs to be corrected, but.
Oh, okay.
Well, here's the challenge. Challenge is that.
Oh, God, you want to come over there in the middle.
You need to, or it seems like you need to have a transcription of the tape so you can kind of figure out, well, what was said so that you can get the exact time marks. So, an agreement. And you don't have that. That hasn't been sent out.
We have it now.
She just want him to look at her. And so she gonna stand in front of him.
Can we take up some other witnesses or hear some other testimony while that is being done?
Well, it's already been done.
Yes, because the transcript, because it seems
She
to
got an
me,
excuse for
I'm not
everything.
gonna be able to kind of rule upon this until you all have the exact time or what is said, so you all can kind of say, okay, listen, we want to chop out from here to here, we agree, here to here, we don't. Here, and I can kind of then look at it from that perspective.
Your Honor, if I may request something on the court, since we have an opportunity to check it for corrections, but since we have a transcript that we can provide to the court and to counsel for the
I think she kind of slacking on her job, Your Honor, as a lead prosecutor.
to identify the portions, the segments, with the appropriate times that they come up, the specific lines in this 161-page transcript that they are asking to be taken out. Since they have already time-hacked it, they should be easily able to find the portions in the transcript, even if the words are not always exactly correct.
Uh-huh.
At least give the
Yeah.
state, some hours, so at least by 10 o'clock tonight, provide to us what specific
Well,
portions they're wanting.
my suggestion is you take that transcript and then the two of you, that both sides sit in here and you figure out exactly what you want to line out and what needs to be, what I need to rule upon.
That's right.
It sounds like you probably have some things that will probably be.
And she gonna do nothing but want to talk.
There'll be a limited universe.
They don't want to talk to
I
her.
gotta kind of consider, but this is not fruitful. This is not a fruitful exercise. It's just not.
So, Your Honor, what we can, do.
They don't want to talk to her.
Is important rest.
Well, that's my suggestion. Because
when we're asking that, the court allow us to report a little bit earlier than
She gonna argue with them.
plan, so that if we don't hash it out right now, we can have the court make that decision before the jury even ever gets in the building. And Your Honor, I can sake of moving things along, I can play portions, beyond anything that we can agree on. I can, play portions of it with the understanding that after the court makes a decision, we are either going to be allowed to go back and play that portion, or we'll just keep moving on without it. But this is something that can be dealt with between now and the time that our first witness is to report tomorrow. This is.
Come on now, stop all that talking and do it.
Will not stop the show. We can.
Okay, you said that before.
And we can stay and we can go over this and we can.
Come on, lady.
As early as the court asks us to. And we can send a report of our.
Still talking.
To the court this evening, so the court is on notice as to what we were able to agree on and not.
They don't want to meet with that woman who don't know how to hush.
Mr. Sharp, I saw you rise.
Your Honor, two things. We have already identified those portions, but the other larger issue that
I don't think you've identified them with they don't match. I mean, because theoretically, what you have and what Mr. Steele has and what the state has should all be in the same. Like the first one I heard, I didn't hear all the words. The second one I heard all the words.
But the larger issue, Your Honor, and I'm just speaking from my experience. Generally, when we've been dealing with prior inconsistent statements, in my experience, it hasn't been someone said something that the state feels is inconsistent, so they just put in a tape. It's focused. If Walter Murphy said the sky was blue, and then on the stand he said it was red, he said it was blue to Investigator Gaither. Investigator Gaither, when you spoke to Walter Murphy on January 1st, 2023, didn't he say the sky was blue? And then that's how they get in the prior inconsistent statement. I don't really understand why we're playing just these lengthy tapes to impeach people focused on the inconsistent statements.
It's not.
Why we're getting in Jacoby Hudson giving, friend talk between Jacoby Hudson and Investigator Dennis and all these other extraneous things.
Yeah.
We're not focusing on the discrepancies.
That's right. Yep.
And to me, that's what prior inconsistency.
Okay, that's one thing, but the state says that the effect on listeners. So what's your take on that?
That is irrelevant. That is not proper to be playing tapes of Jacoby Hudson, who's a witness in this case,
But he's
speaking.
not a witness. He's not.
Yeah, he's not a witness. That's what I'm saying. He's not a witness, and so I don't know why we would.
Why we listen to Jacoby if he's not a witness?
Well, I understand that the state wants to, but
I agree, but his lawyer's statements, Mr. Hudson's statements aren't relevant. They're not.
Your Honor, I had encouraged, because this is how this has gone so far. What the questions have been, uncooperative witnesses have been, did they tell you that you could get out of jail? Did they tell you this? So somehow or another, it's okay that they make an issue out of what the prosecution said, and then we're not allowed to meet that with what he was told by his attorney in the presence of others, so it's not protected or privileged. It is absolutely relevant, Your Honor. It's not, relevance is obvious.
I get that, but but it's very.
Look how she looking at the judge.
Him talking, Mr. Hudson talking about, these sex crimes or shooting.
Don't cut the judge out.
That's not relevant. That's not relevant.
She cut the judge out.
We actually don't have a problem with this. Look, we agree with the ground, okay, we'll take that out. But the portions, and that's why we need to go over, because the portions that we believe should not come out are the portions like that.
That's right. Phelps.
Intimated throughout this trial, people are being.
That's what he's saying.
That they don't like.
Why y'all got him in there? He's not a witness.
Prosecutors are somehow being made that issue. When a person is being encouraged, to be honest, and they have every motivation to. Mr. Murphy got up here in front this jury and he just, decided he was gonna imply that he lied all the way throughout all of his interviews.
You can't talk. Well, those your witness can't complain to judge about your witness making you look crazy.
He was doing what? If he was being threatened with jail time unless he talked, because that's the image that they're getting. And they are asking the court to exclude the state's relevant portions of these interviews with Mr. Murphy and the detectives in this case with his trusted friend, if the court remembers.
But they can't. Don't show witness.
Murphy was asked about on cross.
Don't show witness.
His relationship with his lawyer. And on cross,
it's not their fault.
Asked about whether or not Mr. Hudson paid his bond. So if they're going to be able to bring up things like whether Mr. Hudson
they can
paid
do
his
that.
bond and how close Mr. Hudson was to Mr. Murphy, then the state should be allowed to introduce portions where Mr. Hudson is encouraging Mr. Murphy to just be honest. And he is.
I don't have any issue with that specific, but these other conversations and then talking about other crimes, about improper statements about other people.
Don't cut the judge out.
But they need to be excised. They're not relevant. They're not relevant.
We agreed to take out everything up to that point. That's what we're saying. This is not something that's,
That lady, no, she got, my daddy used to say something about them kind of women.
And if there are portions after that they feel strongly about and they want us to reconsider and look at, then allow us the opportunity to do that. But they're not wanting to do that. They're trying to.
Yeah, and then they don't, that's right. Yeah, she brings him in there.
I guess to wear the court down and have it all taken out. You're just
yeah. She sure do want them to flip. Now sit down so them people can go home to their wife or their girlfriend.
All right. Mr. Adams.
On the lines, wearing the court down, trying to confuse the court. Let's be absolutely clear about one point that Ms. Love is talking about. It. She doesn't appear to really know. Is that it was Ms. Hilton who asked the witness about his relationship with Jacoby Hudson. It was Ms. Hilton who asked whether or not.
Yeah, he tired of her.
Now, nothing in what Mr. Murphy said. He never said, I said what I said, or I did what I did, or I gave this statement because of something that Jacoby Hudson said to me. So just because they want to try and infer that that was part of it, doesn't mean their strategy becomes evidence. There's nothing relevant about what Mr. Hudson is saying to Mr. Murphy. It doesn't become relevant simply because they want to use it. And if Mr. Murphy in his testimony had said, you know what, I would have done anything to get out of jail, or what my lawyer said to me.
That's right.
Some effect on me. And yeah, they could impeach him with that, but he never said that.
Hold on. Let him finish.
Any question about his relationship with Mr. Hudson and how close they
He got on a boy.
It came from them.
God, she just be cutting people out. Look.
He did. He said that.
He said it throughout. Every chance we asked him a question, every time we asked him about this interview, Ms. Hudson confronted him.
See, she like to hear herself to talk. I don't know where she from, but she ain't from Georgia.
And I would say anything. I would say done anything.
But you ain't gonna have your way in this court, girl.
So throughout his testimony on the record, he kept putting forward that he didn't remember and wasn't truthful and had reasons to.
That's your witness.
His impetus to not be truthful was he going to get out of jail. The one thing that is true and obvious from this recording is that the only thing he was asked to do was to be truthful, even by his trusted friend.
That's your witness.
He was asked to be truthful. That's it. So if he had any.
Okay, but that's only a couple of statements from Mr. Hudson, which I agree with Mr. Adams may be marginally relevant in terms of what was said, but I think that he's already been kind of examined on that issue. So.
And he never told the truth about it. He continued to be untruthful.
But that's what the jury's going to decide. That the jury is going to decide that particular issue. But I'm telling you, you get into more problems
running your
in
mouth.
this particular state. You just do.
And, we have to.
No, you-
Right, and this is the state's going to make the decision, otherwise all they heard is him saying, I don't remember. And I would have told anything.
Well, that's what they do in
I
court.
understand that, and that's a disagreement, but that you and Mr. Adams have and Ms. Hilton has, but all this other stuff, not relevant. It's not.
Sure not.
Conversations with Mr.
Man,
with
sit
Mr.
down.
Mr. Hudson.
Why she won't? And she not even listening to the judge.
So I mean,
Her attitude. Sit down. She wanna be a good prosecutor, but she not.
and this transcript's 100. I mean,
The questions that they're asking to be taken out, we in on page.
Well, take it out. Do your job. Right. The real.
what page?
That's her witness.
It's on page 30.
Okay, she said she wasn't telling the truth.
Page 30,
Yeah.
161. The interview with Walter Murphy.
Yes, I think that.
The 18th, the August 18th, 2015 interview.
They think all.
I think that that's what they're asking for, up to, the point where investigative Gaither says where,
Good, something else.
I think the last part where conversation is taking place is Mr. Hudson saying, I got referred to him because his mom and his grandma went to the church praying folks, and I've been mentoring kids there for about 3 years trying to get right. But I can't, keep them away from you all. And then investigative Gaither tells Mr. Murphy, you're gonna have to make some changes. And then, Mr. Murphy says to investigative Gaither, this is the part where,
But what page are you talking
they
about?
started,
30 of 161?
yes, John? I can show you.
She got to come up there to him. I don't want to look at you.
That is the part where we would want to start, we would have no objection to cutting out
That man ready to go.
29, and then up to line 3 of page 30.
Ooh, the country woman, she worse than me.
So that even includes the portion about that, so the judge, I don't.
Yeah, I can read it, man. Judge ready to go through. And then they got to turn around and come there in the morning.
Notwithstanding that we feel that that portion is important, that the jury should be allowed to hear it because it's relevant.
Yeah, I mean, especially, I'm looking at page 30 of 161 councils, which I'll include as the next court exhibit, in order of the August 18th, 2015 interview. Are you under the influence of any drugs, alcohol, medications, or anything like that? Mr. Murphy, no. So yeah, that would be admissible because he testified I was high. So, okay, all right.
And even at line 13, where he says, all right, I'm not gonna lie.
Yeah, I got it.
You remember?
Yes,
Which?
August the 18th, 2015,
She want to be the judge. She was getting ready to answer.
30 of 161.
The state just sent us.
There's three.
Now it's
Yeah, it takes a while to populate, but it should be pages 30 of 161 once it's fully paginated.
Now go sit down.
So what they're willing to do is the state is willing to take out 1 through 20, pages 1 through 29,
Yeah,
up through
they take her
page,
in the
up
court.
through
That's right.
line 3 of page.
That lady over there typing it.
Start at line 4.
Now go sit down. You know.
I advise the rights.
Now go sit down.
Council, my suggestion would be you go through the transcript.
That's what you just said.
Um,
That's what you just said,
flag
Pepsi.
language that you are, that you can agree upon, and, or actually flag the statements that you are in opposition, that you can't reach agreement. I can rule. It doesn't sound like that would be the best way that I think the court could probably rule upon and help you all resolve this.
Now, bye. Sit down.
Just seek clarification. This transcript that was sent to us, is this post redactions of the motion that I filed?
So no, the transcript is the original interview.
It's the original interview.
And so it's just a matter of listening to the originals, because the redactions are like a minute or so long. We will make sure that there is nothing in here that has been ordered to be taken out. We're using this as a tool. We're not giving it to you tonight. So the portions that we have already been ordered to take out will be removed, but we need to use something to further this process along. So at this point, the portions the court has ordered us to take out are out.
They're
The
gone.
purposes of this hearing, they're out. And now we are at the point where we have asked that a time frame be omitted, and we are agreeing to omit the whole first 29 pages up to line 3 on page 30. That, along with whatever the court has previously ordered, that we have out, moving out. Anything else, I just ask that the court have them to let us know by 10 o'clock, because we can have, if there are other things that we can agree to, or something else that they are in opposition to, at least that gives us time to perhaps even agree and make a change. But when people are aware that we're doing that redacting things, it would really help if we could just have all of the precise areas before the multiple redactions are being done, so.
Now have a seat and get your witness ready for tomorrow.
Anything that we can't agree on, I'll ask the court, just,
Yeah, it looks like, hold on, Mr. Sharp. Mr. Steele, it seems like that,
Judge, you think you slick too.
and Mr. Sharp, it seems like you all probably need to kind of refocus what you believe should be in or out. I think you all may be able to do that by agreement.
Your Honor, just humbly, I don't understand if, for instance, if this tape is being played for the fact that Walter Murphy said, I was high during these interviews, and he was asked during the interview, are you on drugs? And he said no. Why, instead of playing a tape, doesn't the state just ask Investigator Gaither, when you spoke to Walter Murphy on August 18, 2015,
Right.
Did you ask him if he was on drugs? Yes, I did. And what was his answer? He said he wasn't on drugs.
Yeah.
That is impeachment by
Instead of putting it on video.
There it is right there. I don't understand respectfully why we are putting in a videotape
Right.
to impeach by prior inconsistent statements.
Right.
tell Your Honor why. Because the videotape shows his demeanor, shows the circumstances, the environment under which he made that prior statement, and the context in which he made that prior statement.
Not what y'all showed us.
It does, Mr. Sharp. So it does.
Not all of it.
It does, but I would concur that some of this stuff here is not, that's in this tape, is in, the interview on the 18th is not relevant. This is not.
And we don't have a problem taking it out. But when
See-
he sat down on that stand and said he doesn't remember anything he said,
But
and even after he.
That's one thing. That's one thing.
We're in agreement. We're okay with whatever. We know.
So what's she trying to say, guys?
Like I said,
Defend it.
those first 30 pages, and if there are other areas that they're just
Give her the information early. That's
So,
what she
if I
said.
adamant about, I don't have a problem looking at that and trying to come to some understanding with counsel.
Y'all need to sit down and talk.
That is what the court has ordered that we do. I thought we were at the point that that's what we were gonna do, but if we're not, and further argument is needed.
They don't want to talk to
let
you.
counsel make their arguments, but Your Honor, I'm asking to have, if there are areas that they want redacted, now that they have a whole transcript, just tell us the lines so we can know if we agree or disagree. And
Yeah,
if
that's
we
good.
tell them why we disagree. And we can have a very targeted argument before the court, as opposed to.
The way y'all argue gonna be.
Telling the court, generally speaking, what's being said.
Okay, I'm gonna tell you that most of the statements with Mr. Hudson should probably be excluded, other than the ones that he's talking about his client and telling him to tell the truth and advising of his rights. Because that does go contrary to what he's testified to.
And there are areas where Mr. Hudson asks someone to clarify a question so that
She ain't gonna shut up now.
can fully understand and answer it as accurately as he could. When Mr. Hudson is
Well, that would
lending
be,
assistance.
that would go to show because he said he was high.
Right.
So, yeah, so yes, that would.
Now go on and sit down.
The
Why don't
other relationship to other uncharged crimes or whatever else, and else is not really admissible.
That's fine, we can do that.
All right.
Now go sit down.
I'm sorry, Mr. Sharp, I apologize.
Your Honor, as the person who controls the courtroom and the way the evidence is presented, I'm just trying to understand, do we anticipate the state would be asking a question? Investigator Gaither, didn't Walter Murphy tell you this on that date?
No.
And then, Mr. Kokomo, would you play at 4 minutes, 30 seconds? Hold on, Miss Love. Would you play at 4 minutes and 30 seconds and then the 10-second clip plays?
No.
And then we move on to another subject?
No.
Or are we, Miss Love, I'm asking the judge a question, okay?
Yeah, he is. So,
Or are we anticipating
She's so rude.
having the state say, Investigator Gaither, did you talk to Walter Murphy on August 18, 2015? Yes, I did. Do you recognize this CD? Yes, that's the recording. And then they just plop it in and play everything. Because I just don't think that's appropriate impeachment by prior inconsistent statement. It needs to be targeted point by point
I
by
agree.
point.
I agree.
And we did. And Your Honor, that's the whole reason we took a painstaking
She is
time
so
to
rude.
confront Mr. Murphy with these different statements. We did the same thing.
They need a judge, another judge.
We have to go through each line.
Get another judge.
We have to go through it and confront him specifically with specific portions. And then they argued about that. They argued that
Well,
him
the
saying
challenge
he
of
forgot
it.
was enough.
Well, the challenge in this is that I think that you do, there's enough, that Mr. Murphy has testified enough that there are a lot of things he's probably gonna be, or some things he'll be impeached as to.
He's gonna get impeached as to everything and Your Honor.
Well,
Come on.
I'm just telling you that I agree with Mr. Sharp, you just can't play tape, you're gonna have to break those down individually into the areas.
She don't want to do that. Look at her.
That you're seeking to impeach him on. For example, his recollection of events or whatever, since he said he was high, well, then certainly playing those particular parts of the tape that would go to show that he had presence of mind to understand certain
Yeah, let me
things.
speed this up. The girl don't got on my new. Oh, they about finished anyway. They about finished, y'all.
And there's nothing in the.
She ain't gonna sit down. Y'all need to talk to her.
And have.
Let me think about it. Why don't you do that? Yeah, you can have a break and I'll make a decision, okay?
Lord God. They tired of her. She just won't sit down. Don't nobody want to talk to that lady. Don't nobody want to talk to her, y'all. Nobody want to talk to her. But honey, she don't make me hungry. I'm about to go. I appreciate y'all watching. Thanks for watching. Appreciate my mod. Appreciate the people for, uh, you know, putting their commentary on there. You know, tell them what you think. You know about this. If they don't sit down and work together, we ain't gonna get nowhere. Okay, but those are witness. It's not the defender fault. Y'all like, share, and subscribe. I'm out of here.